is transforming various domains from governance and security to human rights and legal frameworks. This webinar aims to explore the challenges and opportunities that AI presents to international law with a focus on human rights, global governance, and perspectives from different regions. We will first have introductions of the organizations hosting the webinar. First, I call upon Professor Alberto Malatesta, Secretary General of ILA Italy, to introduce his organization. Professor, if you may please, thank you.
Please open your mic.
Yes, please. Can you hear me? Yeah?
Yeah.
I'm in mute.
Okay. So, good morning again. Good morning or good afternoon to all of you, depending on where you are, of course. And of course, it's a great pleasure to me to introduce this seminar, this joint seminar. I welcome all the participants and thanks all the colleagues who set up this study day. Let me express, first of all, my pleasure with the organization, with the cooperation with such distinguished research centers as the Islamabad Policy Research Center and the Research Society of International Law from Pakistan. The exchange of views among different legal cultures is of paramount importance, of course, today, especially today, where international law is facing at a strong transformation, to say the least. From our side, from ILA Italy side, as you may know, we are members. We are the Italian branch of the International Law Association, that is a global organization with its headquarters in London, and we are strongly committed to promote and develop international law, both public and private international law, through seminars, workshops, international conferences, including policy recommendations to the international, to the main international stakeholders. So we actively take part in several initiatives through the world. And let me only mention the newest initiative from our side, that is to say, the launch of an international legal journal, the yearbook of ILA Italy, published by the leading publishing house, Brill, where we are eager to host views from lawyers, from scholars, from across the world, including, of course, the south of the world. So I really hope that this will be another opportunity to work together and to exchange our views. I don't linger on the issues of the today works. This is up to our chair. I only say that, of course, AI is rocking the world. So it's one of the key topics today. So I'm sure that we will learn a lot from our speakers. And so thank you again to all of you for your efforts in organizing these days. And I give you back the floor.
Thank you very much, Professor. I would now like to request Ambassador Dr. Raza Mohammed, President of the Islamabad Policy Research Institute, to introduce our organization.
Thank you so much, Maham. Thank you, Professor and team in Italy for interacting with us and hosting this seminar, joint webinar together. Thank you so much. And I think this is one of those things we could do more frequently and make this interaction more useful for both the countries and international law at large. Before I go to introduce my think tank and the chair law, a few words about the artificial intelligence. Artificial intelligence is not a new thing, but it has acquired newer dimensions with larger coverage and more impact on human life as a whole. Few people are scared that AI is perhaps going to take over the world and human jobs also, and perhaps the machines will take over the world and it will become a fiction film scene that whole the world is destroyed by the machines and taken over by the machines. This may not happen because ultimately human intelligence remains the supreme, which is the real intelligence, and real intelligence is going to take lead everywhere against the artificial intelligence. When we talk of the AI and law, it can become a very big aid in research, decision-making, make the dispute resolutions more efficient, improve compliance and enforcement of law, and strengthen cybersecurity and anti-corruption efforts also. In the humanitarian assistance, AI could actually help and assist largely and overcome the crisis efficiently and more quickly. But at the same time, there are some drawbacks also, which we'll have to look into, that what are the negatives of the AI which relate to the international law, especially when it is related to the privacy violations, censorship, and freedom of expression. Maybe if we rely too much on the machines for preparation of our cases, it may be sometimes black box justice. So we are just depending upon the machine. So human will remain always important. And some people fear that perhaps the jobs will be also taken over by the AI. More important challenges which we need to look into is the transparency and accountability. The human oversight is very, very important, and especially when it is the data gathering and all that, we give consent whenever we download a new app, but it should be informed consent. So these are a few words which I wanted to say about the human intelligence and artificial intelligence. I'll come over to the Islamabad Policy Research Institute, what we are doing, and about our chair of the international law. Islamabad Policy Research Institute, we call it IPRI, IPRI, is the short version. It came into being about 25 years back. It is one of the oldest, very esteemed think tank. It is quasi-government think tank. We are affiliated to National Security Division. Over the years, it has become internationally recognized premier think tank. And our research focus is basically on the policy inputs. We work on those areas which can actually help improve governance and also security, whether it is traditional security or non-traditional security. We have two chairs with us. One is the international law and one is the economic security. Other than that, we have advocacy department and communications. We have a director of research with us. We have research fellows like ambassadors who look after the international affairs. We have a research fellow who works on the nuclear, biological, and chemical weapons and regimes related to the nuclear weapons. We have director of administration and finance as well. When it comes to chair international law, you know, Maham is sitting right next to me. She is a Yale graduate. She is here for past 2 years, chair law with her associates who are sitting, the young and brainy ladies here. And one of the assistants is sitting in the rear. If you focus the camera on that, Abdullah, they can see him also. They all work together on various things, especially international legal issues which affect Pakistan. And it spans a wide array of public, private, international law topics. We have strong focus on intersection of international law, AI, and emerging technologies. We are working on the transformation of the governance, whether it is the country's governance or the global governance. And department actively engages in policy advocacy and expert consultation and dialogues. Our chair of international law holds the schools and workshops also. These schools and workshops are aimed at capacity building of the junior, younger lawyers and people from non-law fields, even in international law and related issues. We are linked with the business community also through an economic think tank, which we call Economic Policy and Business Development Think Tank. That is one of our partners in the international law. So with these remarks, I hand you over back to Maham. Thank you, Maham.
Thank you, sir. So we are privileged to have an excellent lineup of speakers today. As a matter of housekeeping, each speaker will present their initial insights for 15 minutes, which I'm apologizing in advance. I'm going to regulate very strictly, followed by an interactive discussion and a Q&A session with the participants. We encourage all participants in the meanwhile to share their thoughts and questions in the chat box, and we'll keep on writing them down and we can ask the speakers in the end. You can also direct your question to a particular speaker if you so wish. We will now start with a brief introduction of the speakers for today's webinar. Our first speaker is Professor Roberto Ruopo. Professor Ruopo is a PhD in international law, a lawyer and assistant professor of international law at Marsh Polytech University. He is also professor at the Luiss University Faculty of Law in Rome. Professor is also the author of a monographic work and several scientific articles in the field of artificial intelligence. He is a member of the Italian Society of International Law and of the Italian branch of the International Law Association, and works in the editorial boards of leading international law journals. Our second speaker is Dr. Sadia Zahoor. Dr. Zahoor is a PhD in international law and a policy and non-traditional security expert. Dr. Zahoor served as a policy expert on non-traditional security and international law at the National Security Division in the Government of Pakistan. Previously, she has worked as a legal consultant at the International Committee of the Red Cross and served as an assistant legal advisor at the Ministry of Foreign Affairs in Islamabad. Her recent work explores Pakistan's international law challenges in 2025. Our third speaker is Mr. Ras Nabil. Mr. Nabil is a senior research associate at the Research Society of International Law. He holds a BA LLB degree from the Lahore University of Management Sciences and an LLM in international law from the University of Cambridge. At RSIL, he runs the Center of Human Rights, analyzing Pakistan's key human rights issues from an international legal perspective. He also has expertise in environmental law, international humanitarian law, and law of the sea. Without further ado, I invite Professor Roberto to begin his presentation titled The Need for Global Governance of AI, European Human Rights-Oriented Perspective. Professor, you have the floor.
Thank you very much, and good morning and good afternoon. I hope that you are able to hear me. So I kindly ask you if you are able to hear me. Okay, yes. Thank you very much. So first of all, I would like to thank the organizing committee and in particular the Islamabad Policy Research Institute and the Research Society of International Law. But also let me thank to Professor Tanzi, Professor Malatesta, and Professor Donato Greco for involving me. Well, the topic of my presentation concerns the European answer to the artificial intelligence challenge, and in particular, how the European institutions' answer is a human rights-oriented answer in order to be able to face artificial intelligence challenges. When I talk about European institutions, I refer both to European Union institutions on one hand and on the Council of Europe as well. Well, why do we talk about the need for a global governance and a human rights-oriented approach by European Union institutions? Well, technological development and the spread of AI systems have drawn the attention of international literature because of the significant implications associated with the use of such tools, which are capable of providing considerable benefits, optimizing and improving every economic sector, as the president of the Islamabad Policy Research Institute was saying before. Meantime, the development and deployment of AI tools are capable of providing several risks as well, particularly from the standpoint of the protection of users' rights. Indeed, there are several rights that are likely to be infringed by the misuse of this technology, undermining the very trust of users, as a number of disputes that have recently arisen both outside and within European borders demonstrate. Outside the European borders, reference could be made to a decision rendered by Wisconsin Supreme Court in the so famous Loomis case concerning the right for a fair trial and the due process right. On the other side, within European borders, a very famous case has been decided by the Hague District Court concerning the discriminatory input of AI tools in administrative proceedings. Actually, there are several risks associated with the uncontrolled use of artificial intelligence. Just to make some examples, AI can contribute to the dissemination of false information that may manipulate the public opinion and undermine public trust in the fairness of democratic processes. The exploitation of algorithms that are both unclear and tainted by discriminatory input can affect the functioning of the judicial system and undermine the right to effective judicial protection. Furthermore, mass surveillance made possible by the use of recognition tools that rely on the collection of biometric data carries the risk of undermining the enjoyment of certain fundamental freedoms, including the freedom of assembly or expression. Well, to successfully integrate AI into the global economy, there is a need for an effective governance capable of managing risks and ensuring fair outcomes. In this regard, it must be pointed out that the physiological absence of domestic boundaries in digital relationships evokes the need for supranational regulatory intervention, functional to standardizing the legal treatment of new technological models, and at the same time to ensuring their compatibility with the rights of individuals. Indeed, digital relationships, which make use of online tools and information societies technologies, are not limited to well-defined national boundaries, but rather seek to cross domestic borders, thereby involving a plurality of actors of different nationalities. Therefore, for the legal instruments to be capable of providing effective regulation of such relations, they must be adopted at the international level in order to overcome the fragmentation inherent in the proliferation of national rules. If we observe the current legal landscape, we can say that it is characterized by considerable uncertainty and fragmentation, given that on the one hand, there is a proliferation of national regulations, and on the other, most sources of international law are of a non-binding nature. Hundreds of guidelines, frameworks, and principles have been adopted by governments as well as by regional and international organizations, such as the OECD, the Organization for Economic Cooperation and Development recommendation, the UNESCO recommendation, and the United Nations General Assembly resolution of 2024. It is not a coincidence that the absence of a supranational legal framework capable of introducing uniform obligations has been recognized as the most significant critical issue in regulating the AI phenomenon, as highlighted by the advisory group appointed by the UN Secretary General in its final report of September 2024, entitled Governing AI for Humanity. It is against this background that the Council of Europe Framework Convention on Artificial Intelligence and the European Union regulation, the so-called AI Act, have been adopted. And their most significant contribution lies in having enhanced the role of human rights protection in regulating AI tools. The European Union regulation represents the first attempt to organically regulate the phenomenon of AI, representing a paradigm for the regulatory activity of other international players, as has already been the case with the General Data Protection Regulation, the so-called GDPR. While aiming to balance the protection of users' rights against economic needs, it establishes already in Article 1 that its main purpose is to promote the deployment of anthropocentric and reliable AI, ensuring a high level of protection of fundamental rights. As regards the Council of Europe Framework Convention, it constitutes the first international treaty on the subject having a universal scope, due to the participation of several non-member states in the negotiations.
Devo scendere con te così. Ti volevo anche dire, bisogna portare fuori la spazzatura anche quando finite.
And due to the accession clause, as per Article 31, I think that someone has forgotten the micro open. Okay, unlike the AI Act adopted by the European Union, it focuses exclusively on the human rights aspects involved in the use of AI systems, and not also on economic and commercial issues. As stated in Article 3, the main purpose of the Convention lies in the protection of human rights at every step in the life cycle of AI systems, due to the concerns related to the use of AI, the malfunctioning of which can contribute to altering the trusting relationship between citizens and public institutions, thus sacrificing the integrity of democratic processes. The Framework Convention aims to extend previous human rights provisions, such as those established in the European Convention on Human Rights, to the life cycle of AI systems. The most significant effects attributable to the two normative texts mentioned above run along two lines. Firstly, on the taxonomic level, so focusing on their scope of application, they adopt the same definition of AI, uniformly identifying the scope of application and achieving the normative alignment so wished for by the United Nations Advisory Group. These notions are provided by Article 3 of the AI Act and Article 2 of the Framework Convention. And following a definition that was already adopted by the OECD and by UNESCO as well, they will help to predict which kind of applications and tools will be governed by these legal rules, thus safeguarding law certainty. In the same perspective, they refer to the same life cycle steps of AI tools. The most important are design, development, validation, and implementation. Secondly, in terms of content, both normative acts place the need for the protection of users' fundamental rights at the forefront, outlining a renewed interpretation of human rights, such as the principle of transparency, the protection of personal data, and the principle of due process, for example. Focusing on the EU AI Act, the approach followed by the EU institutions, and so the search of a balance between technological developments and users' rights, has determined the adoption of a risk-based discipline, modulating regulatory restrictions according to the type of interference that specific AI tools are able to create. Hence, EU institutions have established prohibitions for AI systems determining unacceptable risks for human rights, such as mass surveillance and facial recognition through the employment of biometric data or social scoring systems. In this regard, Article 5 is particularly clear. A step below, we can find the so-called high-risk AI tools, in such way identifying those systems able to infringe human rights, such as softwares for credit scoring and risk assessment tools in criminal proceedings. In order to ensure that AI is reliable and ethically sound, it is established that high-risk AI tools should be put into the market, provided that they comply, for example, with the principles of human oversight, respect for privacy, transparency, and the promotion of diversity. It is noteworthy that the same principles and requirements have been provided by the Council of Europe Framework Convention too. Articles from 6 to 13 are particularly clear. Some examples can be useful in order to understand the impact of the European legal rules. The principle of human oversight, that was firstly named by the president of the Islamabad Research Center, the so-called also human in the loop principle, is pivotal, alluding to the need for AI systems to be developed and deployed in such a way that they can be adequately controlled by humans, preventing users from suffering detrimental treatment as a result of a mere algorithmic determination. Although this safeguard finds its normative antecedent in Article 22 of the EU GDPR, it takes on new nuances in the context of AI. It implies, for example, the need for the operators in charge of using an AI system to have the necessary tools to ensure continuous surveillance of the AI system's operation, avoiding any misuse and, when needed, overriding its outputs. As regards the principle of transparency, it is useful in fulfilling certain well-defined tasks in the operation of AI systems in order to overcome the opacity of algorithmic tools. It includes the obligation to disclose the interaction with an AI system and the so-called explainability. Firstly, the fact that a user is interacting with an AI system must be made known to him or her, and the providers of such systems must guarantee that the outputs generated in the form of audio, image, or video content are detectable as artificially generated. Secondly, the explainability of AI system aims to ensure understanding of the decision-making process for every recipient, regardless of the level of education or prior technical knowledge. This requirement is crucial in order to overcome the physiological opacity of algorithms, often identified through reference to the so-called black box effect. For example, access to information concerning the operation of risk assessment tools for those charged by a crime could help challenging their results and ensuring the principle of equality of arms between the prosecuting authority and the individual concerned. The transparency provision seems to have been formulated for the specific purpose of avoiding the occurrence in Europe of events detrimental to fundamental rights resulting from the application of algorithmic tools whose operation is characterized by high opacity. In the light of Article 86 of the AI Act and Article 8 of the Framework Convention, it would be reasonable to exclude the use, for example, of AI systems in the context of criminal proceedings without adequate illustration of the logical steps that led to the adoption of a given decision. The fact is far from obvious if one considers the different treatment of the same principle of transparency that is provided in other legal experiences, as was the case in the United States in the well-known Loomis case decided by the Wisconsin authorities. This case concerned the criminal conviction of a US citizen whose sentence was determined through the application of an algorithm that made it possible to detect the risk of recidivism on the basis of the defendant's profiling, thus enhancing personal circumstances such as age, residence, social class, and ethnic origin. Given his conviction in the first instance, and following an investigation conducted by a non-profit organization that noted the discriminatory nature of the algorithm used, the US citizen filed an appeal before the Wisconsin Supreme Court on the grounds of violation of his right to due process and the related right to equality of arms because of the hidden reasons behind the AI output. The appeal was, however, dismissed because the source code of the algorithm had been disclosed to the defendant, not hindering, in the opinion of the US Supreme Court, his defense. The merit of the EU regulation and the Framework Convention stands in having given a marked impetus to the recognition and evolution of the principle of transparency, which in the new technological context cannot be limited to requiring the formal sharing of the material supporting a given measure, but requires a clear and easily understandable explanation for the recipient, ensuring the discovery of the reasons behind the final decision through non-technical knowledge, through non-technical language, intelligible regardless of the level of technological education. A similar novel contribution can be appreciated in relation to the requirement of the need of a law provision for the employment of AI tools able to provide facial recognition for crime prevention activities. In its first decision concerning these tools, the European Court of Human Rights has stated that the existence of a national law allowing such a use of the system is not enough, but compliance with other features is mandatory, such as the identification of the authority entitled to collect personal data, the time limit for their recording, and the proceeding for their erasure. In conclusion, as has been highlighted, the European Union and the Council of Europe have outlined a uniform regulatory framework with the primary purpose of creating the necessary conditions to ensure the development and use of AI systems, and that they take place in such a way as to guarantee adequate protection of users' rights. The new legal rules have the merit of not only clarifying, but also enriching with meaning the fundamental rights already recognized in the European Union Charter on Fundamental Rights and in the European Convention on Human Rights. Both the Framework Convention and the EU AI Act will contribute to the adaptation of fundamental rights with respect to the current social context, dominated by technological development and the spread of new AI systems, by serving as a normative paradigm useful in defining a global governance of artificial intelligence through the development and evolution of fundamental human rights. The hope is that these regulations will help creating a widespread international culture concerning the hierarchy of values that must preside over the exploitation of such technology, affirming that there can be no progress without adequate protection of fundamental rights.
Professor, I'm sorry I'm cutting you, but you will have 1 minute to wrap up, please.
I have not understood you, sorry.
Sorry, Professor, you have 1 more minute to wrap up your initial presentation.
Well, actually, my presentation is over. So if you have questions or some doubts, you can ask as you want.
Perfect. We're going to do that after everyone's given their initial presentation. Perfect. Thank you so much,
thank you very
Professor.
much.
Thank you.
Thank you.
I think part of what you said about the supranational regulatory intervention on AI, and especially balancing AI with human rights concerns, was very interesting. This brings us to our next speaker. I would now like to request Dr. Sadia to take the floor for her presentation titled International Humanitarian and Human Rights Law, Shaping AI Norms to Address Privacy, Bias, and Protection Issues in Muslim Societies. Dr. Sadia, you have 15 minutes. Thank you.
Thank you, Maham. Thank you for having me and giving me this opportunity. It's like a bit of ironic that my first interaction with ILA is actually through ILA Italy and not ILA Pakistan. And I don't want to say more about it, but nevertheless, I'm really honored to be part of this. The first thing is I want to discuss is why I chose this topic and why I want to talk about the concerns of Muslim societies. Because privacy and bias are universal concerns. So you could people could ask me, am I like trying to say that AI should accept Islam or convert to Islam? I mean, this is about a question that an article last month asked. The title of the article was, should AI convert to Islam in Diplomat? Obviously, I'm not saying that AI should convert to any religion, Islam or otherwise. All I'm saying is it should be a system of fair and just system that protects the rights of all people, including Muslims. So then the question is, are there any unique challenges that Muslim societies are facing with regard to AI? I wanted to give you a dramatic example, but I'm sticking to some normal examples. So there are two important. So let's take this example. In Pakistan, at least, and in some other countries, there is now AI-powered fraudulent journals. They are working. What they do is that they publish AI-generated articles with the names of some important and famous practitioners and scholars, just to lure more scholars who are desperate to publish because of the requirements of the universities and the Higher Education Commission in Pakistan. And when they see the name of these big authors, they tend to publish their articles there and pay a journal for publishing fee. Now, and most of the time, these authors have no idea that there is an article out there with their name on it. So now imagine that if this AI generated article contain controversial content, let's say the content is against the principle of some of the organization, then probably that scholar and practitioner is blacklisted by the particular organization, even without them knowing about that. Which can blacklist them, then they can lose a lot of opportunities. But God forbid if the content is even more controversial, let's say some sort of blasphemous content, that particular person, without even knowing, would possibly can lose his or her life in most of the Muslim societies. And obviously, I'm not exaggerating. We all know that these are the effects. And now think about another situation, which is a deep fake technology. Now they can produce pictures and videos which are now very difficult to distinguish whether they are fabricated or real. And any sort of fake video, breaching on the privacy of people will cause any sort of emotional distress to anybody anywhere in the world. But when you talk about Muslim societies, women can actually lose their lives, their liberties. So, actually, my fear is that this misuse of AI can lead to undo the progress that a lot of women in a lot of Muslim societies have made. I fear that they might be forced to go back, probably in more exclusion and less participation in the society, because everywhere we go, as we will discuss, data has been collected, the facial recognition technologies and AI. Is always collecting our personal information. Now, the question is why still these issues maybe are the internal dynamics of most Muslim societies and not a per se an AI issue, especially the reaction. But there is one more challenge that we need to understand. If we see the list of top 10 AI countries or top 15 AI advanced countries, you will find very few Muslim countries there, and a couple of Muslim countries that you will find on some of those lists are not there because of R&D, research and development, but because they are because of their economy, which essentially means that they're rich countries and they can afford to have this environment where AI companies can work. So why that matter is because that means that the less and less people working on AI technologies, on those programs, on data collection are Muslims, and because of that lack of diversity, fundamentally programmers and researchers don't understand the special dynamics that Muslim societies and Muslims have. And because most Muslim countries are not an active AI players, they are also not actively contributing to the international norms and development. In fact, we are actually passive receiver of international norms in most of the issues, which means that international organization, Western countries, European in this particular regard, and in North American countries are setting the standards for the AI development and norms and international law, and we are just passively accepting this. But the biggest problem is that we consider AI as neutral, but AI is not neutral. It has its biases, and its Muslim bias is prominent. And I'm not saying this, but a lot of researchers have worked on this. For example, when OpenAI ChatGPT 3 was launched, a lot of researchers have actually worked around it and discussed how when you give it a prompt about Muslims, it will always end up linking Muslims with terrorism, violent extremism, and these were the favored words of ChatGPT with regard to Muslims. So this is one example, and we will see how other technologies have biases against Muslims. So now, obviously, if you will search for ChatGPT 4 or something, you will not find those answers because it has been cured. But these are the fundamentally maybe artificial or forced positives now. But imagine inherent bias in those data, because there is inherent bias in the society against Muslims. The data that these algorithms and programs are developed on are inherently biased, and those people who are working on these algorithms, they might have a latent bias as well, and that essentially affects human rights of Muslims. not only in Western societies, but also in Muslim societies. We will discuss how. The first thing that I want to discuss is facial recognition technology and how it is violating human rights of people generally and Muslims specifically. So essentially, this facial recognition technology that we see everywhere, even in countries like ours, where we have these safe city projects, and wherever we go, these cameras actually collect information without us knowing. So now imagine when you are using a website or giving your information, the website will ask you whether you want particular cookies to be used or not. But when you are moving on a road, the camera is taking your picture without your knowledge, without your authorization, and collecting that data. Now essentially these were to control crime and to ensure public safety. But now we know that these technologies are being used as for mass surveillance, and essentially without legal safeguards, because even in globally there are not enough international law to protect our rights. But with countries like ours, where we don't even have a decent data protection laws, most of the Muslim countries and a lot of Muslim countries have these authoritarian regimes which have less respect for human rights. So there is less of accountability of, and then again, not only the government is saving and recording this data, but a lot of private sector people have access, and international some private entities have access to that data that can be misused. So now imagine a city like London, which has like almost 1 million cameras, and apparently, when you move around the city, probably every single individual has like 300 times captured by a camera, and that sort of information. Now they know the pattern of your life, they know your association. So that, and your obviously with your, as a professor said, your age, your date, your gender, your racial profiling, everything has been done by this data. Now the core challenge is that it is exposed for misuse and exploitation, and once the data is breached, especially with regard to your facial recognition or facial identity, so see, you can hide your other identities, you can change your passwords, but once your face
next Friday, yeah.
But once your facial identity is exploited or leaked, you can't change your face, and it's impossible to protect yourself from harassment and other misuses. Now, a lot of this technology has been used to trace people, trace criminals, but then this technology is not 100%. It still has false equivalence. It has a high error rate, especially for people of color. And we have seen these technologies getting banned or temporarily banned, especially in some American states, because of false equivalence and false results of these technologies on minorities and people of color. So that puts Muslims, along with a lot of other minorities in these Western countries, under special challenge. So imagine now this technology has its bias, and then a lot of these law enforcement in these Western countries also have bias, maybe active or latent, with regard to Muslims, and that combination of AI with bias and the law enforcement with bias have a toxic combination which can play havoc in the lives of ordinary Muslims and other minorities in the Western countries. Another special challenge is that although Muslim countries and Muslim governments do not have enough resources to develop their own technologies, but they do buy these technologies from developed countries and then use these technologies against their own people, especially people who are critical of their governments, often human rights advocates, and then there is a type of technology which is made specifically to target Muslims. So I don't want to take names of governments and states because I don't want to put anybody in trouble, but there are countries, their security, you get this information from internet that find who have deployed a surveillance technology to monitor Hajj, which is annual pilgrimage of Muslims. And what is the fear? Why they have this facial recognition technology employed during the Hajj is that probably they think that anybody who's attending Hajj is probably an Islamic extremist, and that can lead to a lot of problems. Because because the human rights essentially give us the right to pray and worship freely without this fear of surveillance by government. Then there are other countries who are allegedly committing genocide against Muslim minorities, and then they have these automated alerts with the surveillance cameras automatically release this alert to the police that a person of a particular community is now in public, and they can trace him and track him, which is like a scary thought. And then there is also a technology employed by the same company to detect emotion of Muslim minorities in their country. Now imagine that technology is able to see and monitor the change in the pores of a face. So they have this technology which is sort of able to identify a person of a specific racial background, because the religious minority is also ethnic and racial minority. So these are the scary thoughts. These are the AI tools make specifically for to target Muslims. So, as I said, that a lot of these European countries have these safeguards, and as a professor said, a lot of case law also, or some sort of protections available at least to protect them against the violation of these data and misuse of the data. So within the Muslim countries, we need effective laws that can protect our data, the collection of data, and how it's used, and it should be used only for the purpose that it has been recorded. And protect ourselves from unnecessary surveillance and tracking of by governments. Now think about IHL, which is even more confusing, because when it talks about privacy, IHL doesn't give much of protection against violation of privacy during armed conflict. But as we know that even during armed conflict, most of the human rights are still applicable, and the right of privacy is protected. And then we have this customary international law, but also Article 36 in Additional Protocol 1, which is not signed by most of the military powers of the world, including my own country, which requires to review every single new weapon and means and methods of warfare to be in accordance with the principle of IHL, and there has to be proportionality, which has to be ensured. The technology has to be able to distinguish between combatant and non-combatants. Now, so for every single AI led project also has to be reviewed, including for a protocol with regard to privacy and data collection and retention. Now, I want to give you some examples of how these mass surveillance technology used during armed conflict was made specifically to target Muslims, because unfortunately after 9/11, most of these issues were the war on terror was against Muslims, and a lot of conflict today in the world involves at least one Muslim group or Muslim state, unfortunately. So,
Dr. Sadia, you have 1 minute to wrap up, please. Thank you.
In Pakistan alone, we have seen that when the drones program was launched by the US, it has the pattern of life and analysis of data, live data that it has been collecting, and it led to a lot of misidentification. We have seen that they have mistaken a funeral for militant activity, and this mass surveillance, constant surveillance by drones have also psychological effect. We have seen that in testimonies. Similarly, there was another program, Skynet, which was also launched in Afghanistan and Pakistan by US, which will use to track militants based on the metadata. And we have seen that they have misidentified some journalists just because they have this, they were operating in a particular area, had call records, access to some of the militants because they were journalists after all. And I don't want to go more into how the AI has been used in the occupied territories in Palestine, but we have seen how they have there are reports of possible bias. Lastly, there is a risk that these AI have during armed conflict have a false results, because they can take any devout Muslim, because the data has been infeeded into them to actually see what are the signs of a terrorist, and that can lead to any devout Muslim to be categorized as a terrorist, which is in violation of IHL, which prohibits any sort of discrimination based on race, religion, and political beliefs. We need more involvement of Muslims. Maham, I'm concluding, which is we have to make sure that more Muslims are involved, not only in the data collection. The data has to be data itself has to be unbiased, and we have to ensure the labeling, the programs that have been developed around those data should ensure that there is less discrimination against Muslims. But there has to be a progressive laws, both IHL laws and international human rights law and humanitarian laws, to make sure that all sort of minorities and Muslims are protected from the bias of AI. Lastly, domestic laws also have to be ensured to protect the privacy of people and the collection of data. International organizations and companies should also consider that they should not have double standards while collecting data from European countries, let's say, and from countries like Pakistan and other countries from the global south. Thank you so much.
Thank you, Dr. Sadia. That was very insightful on the special dynamics of Muslims and norm development in international law, particularly the domination of Western narrative in AI regulation. I would now like to request Mr. Ras Nabil to first introduce the Research Society of International Law and then present his insights on global South perspectives on AI regulation. Mr. Nabil, you have the floor, please.
Thank you so much, Maham. Hello, everyone, and Assalamu alaikum. Before I begin, could I please ask if I can have screen sharing access, because I prepared slides for my presentation. I believe IPRI has organized the Zoom link, so if I could please get screen share access. Okay, yeah, I think I got it. Thank you so much. All right, is my screen visible?
Yes, you can see it.
Okay, thank you so much. Hello, everyone. Thank you to ILA Italy and IPRI for being the co-hosts of this webinar on AI regulation and human rights. My name is Ras Nabil. I'm a research associate at the Research Society of International Law. Before I begin my presentation, I would like to first introduce the organization. So RSIL is an organization in Pakistan that curates legal and policy-based solutions to Pakistan's key governance issues. Our work spans multiple disciplines. We work in human rights law, environmental law, the law of armed conflict and international humanitarian law, as well as trade law, good governance, and multiple other areas. We're a very multifaceted team. We have a lot of expertise across a range of different disciplines. Our interventions are research-based, and they're backed by international law and best practices. And we also engage in capacity building and education on international law and its impacts on Pakistan's governance structures, law, and policy. So with that, I would like to now formally begin my presentation. I'm going to be exploring global South perspectives on AI regulation. And what that basically means is I'm going to be exploring how different states or different regions in the global South have approached the concept of regulating AI, and what some of the challenges may be in approaching AI regulation. We're going to look at different approaches in terms of how a particular state in the developing world is perhaps a bit more developed than others, and how that translates into more robust regulatory mechanisms as well. So in terms of the need for AI regulation, we've already seen several examples of AI misuse leading to human rights violations. A few examples are on the screen. And these are just some of the effects we've seen over the past few years. AI continues to evolve, continues to develop, so we don't necessarily know the full scale of what AI can do and what sort of harm AI can cause. So we need to be able to preempt certain harmful consequences and be able to prevent those from actually materializing, which is why we need clear legal and regulatory frameworks to ensure the prevention, but also access to justice for those who are affected by the harmful use of AI. So I just want to go over some of the challenges for the Global South when it comes to AI regulation. Of course, we know that AI development is still concentrated in places like Silicon Valley and other areas in the global north. And so the global south is trying to, it is trying to catch up to the global north. And in doing so, it lacks a lot of the key infrastructure that is necessary to avail proper AI use, but also to avail proper AI regulation. One report suggests that we need robust internet access. We need to provide robust internet access to almost 2.6 billion people across the global south for us to fully reap the benefits of artificial intelligence. But that's also a problem because you have resource constraints, not just in terms of financial resources, but also the technology and the technical expertise on AI programming, and informed policy making. We also lack robust data protection mechanisms, particularly in Pakistan. As Dr. Sadia pointed out, we do not have a data protection law, and that is obviously a necessary precursor to the responsible use of AI. We also see relatively low digital literacy across the global south, particularly in rural areas where access to education and connectivity issues prevail. And all in all, as I mentioned before, the global south appears to be playing catch up to the global north because of the sort of economic boom that AI appears to be, exhibiting, or the AI boom that the global north seems to be exhibiting after investing in the technology. And so what we see in a lot of the designs of global south AI policies is that there's a lot of emphasis on investment opportunities and economic opportunities, and there isn't necessarily the same emphasis on prioritizing the need for proper governance to prevent the harmful use of AI. So with that, I'd like to move on to one of the approaches to AI regulation across the world, and that is ethics-based regulation. A lot of international organizations such as the OECD, UNESCO, and recently the UN Advisory Group on AI have come up with these principles of what is considered responsible or ethical AI, and some of those are on the screen, as you can see. So human-centered design, that there should be a minimum level of human intervention necessary when an algorithm is activated. Sustainability, that AI should be used for good, but again, not all such documents have clearly defined what sustainability means. We also do know that AI is notoriously terrible for the environment as it currently is. Fairness and non-discrimination. So how do we mitigate algorithmic bias, which also Dr. Sadia mentioned. Accountability, transparency, safety, and security. Again, those are just echoing past sentiments. As I mentioned, international organizations have developed these guidelines, but so have private companies, AI developers, and technology companies such as OpenAI and IBM themselves. So that also does call into question whether developers themselves are in the best position to regulate ethical AI for themselves, or whether there should be an overarching legal framework, policy framework mandated by states to ensure ethical AI use, which is what I argue for. And that is the human rights-based approach. That we need to incorporate law and policy, a top-down approach, so to speak, to ensure that AI is used sustainably in a manner that avails economic opportunities, but at the same time mitigates harm. What does that mean? We need to have clear definitions of what is and what is not responsible AI. We need to have legislation and policy measures to ensure that the deployment of AI and technology does not compromise human rights. We need to be clear on what liability mechanisms we use. Are we going to put forward the strict liability approach on the supplier or the deployer of AI systems? What institutional mechanisms are necessary, and what grievance redressal mechanisms should be in place? So these are the two broad categories of approaches. I'll now move on to some of the regional initiatives that we see across the Global South on how to approach AI. So the ASEAN region, the Southeast Asian Nations Association, have developed a guide on AI governance and ethics. And in said guide, they've also adopted the principles approach. So they've used the ethics-based approach, transparency, fairness, security, robustness, and human centricity, among a few others. Their approach is also multidisciplinary, so it incorporates law, policy, as well as technology, economics, and other disciplines. And they focus on developing internal governance structures, which we'll explore later with the example of Malaysia. They also emphasize conducting risk impacts and management systems and adopting a life cycle approach. So ensuring that the developers are able to assess the impact of the AI system throughout its deployment, its use, and then post-use. And it also focuses on stakeholder interaction and communication, so informed policy design. On the other hand, you have the African Union's continental approach to AI, and that is definitely more human rights centric. So it recognizes the importance of the protection of human rights, fairness, data privacy, and equality within its guiding principles. It also emphasizes the importance of an African perspective of human rights protection, so particularly in line with African values of collectivism. And it also ensures that AI should not, or it tries to ensure that member states do not use AI to subvert traditional community knowledge and do not use AI in such a manner that it marginalizes vulnerable communities. Now that we've looked at some of the regional approaches, we'll now look at some examples across the global south, so individual states. And I've picked these examples to show you the sort of range in approaches that we see. And perhaps we can see that there is a clear trend of economic development and also AI policy formulation. And then what should these states, what should the broad approach to AI regulation generally be? So in Pakistan, as was mentioned before, we do not have a law on AI or a law on data protection yet. It has been tabled, and currently we have the cybercrimes law, which governs these particular issues. We have a draft AI policy, but that is also not necessarily in its final form. The policy, as far as the draft is concerned, focuses on utilizing AI technology to develop the tech sector, healthcare, education, and food security. And it's mostly seen as an avenue to create jobs and economic opportunities for investment. But there are very few details and there's very little information on what exactly ethical AI is. What exactly are the guidelines for what ethical AI is? And of course, without even a principles approach, it's very difficult to then formulate a human rights-based legislative approach to ensuring that AI is only used in an ethical or responsible manner. Next, we look at Malaysia, which is again part of the ASEAN region. So it has drawn upon the ASEAN Guide on Governance in AI. So in Malaysia as well, we do not necessarily see particular legislation on AI, but they have formulated an AI strategy. So it is a policy. And part of that policy are those ethics-based guidelines, as mentioned before. It primarily places obligations on AI developers and deployers to ensure the protection of end users. So it's mostly a self-regulation model as opposed to a top-down state-based regulation. They've recently launched a national AI office to develop those policies and address regulation. So we're hoping that this approach evolves into a human rights one later down the line. They do have a Personal Data Protection Act, which ensures the protection of data, particularly when it comes to its use in AI systems. And the policy focuses again on leveraging AI for development, investments, and industrial applications. So we do see that economic opportunities approach here as well. In terms of Brazil, I think Brazil is quite far ahead in terms of its AI regulation, particularly when we look at it from a human rights-based approach. It recently passed a law on AI regulation as part of its AI strategy, and it's one of the very few countries, the very first countries in the Global South to actually codify responsible AI obligations as opposed to using an ethics-based model. So similar to the EU AI Act, which Professor Rupo mentioned, it has a focus on a risk-based approach. So it identifies certain applications or certain systems of AI which may be high risk and therefore require high regulation. So it requires a risk assessment by suppliers before placing a system on a market. And it also adopts a life cycle approach. So the deployer will manage or will actually monitor the use of the AI system and whether it is being used appropriately throughout its life cycle. And in particular, it does include a rights-based approach. So it covers the right to information, non-discrimination, and data privacy. And I think most importantly, it does mention what the penalties for non-compliance are, which are currently missing in the other two states that I've shown. And so this indicates that there is a focus on defining what is responsible AI with the risk-based model, what the obligations actually are, so the risk management approach and the life cycle approach, and then what are the consequences for non-compliance. So they have clearly mentioned those. So my point in showing all of this to you is to basically show you the various approaches right now to AI regulation, and particularly in the Global South, because, as I mentioned, we are kind of sort of playing catch up to the Global North, where focusing a lot on the economic opportunities that it may potentially bring without adequately preparing ourselves for the harms that AI may cause. And so it's necessary to move towards a human rights informed legislative framework that adopts a life cycle approach, risk management, and also explicitly recognizes the protection of human rights, such that there are sanctions in place and there's an institutional mechanism that oversees the use of AI. Lastly, policy formulation in the Global South, particularly when it comes to AI, should balance the economic opportunities that AI brings, as well as the need for human rights protections through clear legal rules and mechanisms. With that, thank you so much, and I give the floor back to Ipri. Thank you.
Thank you so much, Ras, and thank you for also finishing well before time. We now open the floor for questions. You have two options. You can either raise your hand and ask the question yourself, and we'll unmute you and you can ask the question, or you can write your question in the chat box and we can ask one of the speakers to answer it. If you want a particular speaker to answer your question, you can also let us know. So do we have a question, please? I think I'm then going to ask the first question since there's not one. So my question is a combination of the first two presentations and what Professor Ruperto spoke about the European Union's regulation of AI. Professor, my question is to you, and with regards to what we've heard from Dr. Sadia and Mr. Nabil, do you think the European Union's regulation is cognizant of the racial bias that is present within AI? And do you think the regulatory mechanism that they're trying to put in place is going to do something to counter that and make sure that that particular aspect is also regulated?
We
Can't hear you.
Professor, we can't hear you. Professor, we can't hear you.
Mute. We still cannot hear you.
उनके एंड पे हमारे एंड पे
Mute करके unmute कर।
Professor, we can't hear you.
We can't hear you. Can you unmute yourself, please?
Professor, could you try taking out, disconnecting your AirPods?
And then putting these back.
Still no.
Connected, we can have Dr. Sadia and Mr. Nabil chip in on my question of the regulation for like 30 seconds each. Dr. Sadia?
All the regulations and statements that ever came out of Europe and anywhere else, they always talk about the ethical use of AI and making sure that the AI technologies are used for the rightful purposes. But are they talking about, especially about the racial bias in technologies? I haven't seen anything of that sort. Obviously, I'm not an expert for EU laws. I hope Professor Roper will be able to explain better.
Can you hear me now?
Yes, we can. Yes, we
Okay.
can.
So I'm sorry, I don't know what was happening. But so my answer to your question is absolutely yes. I believe that EU AI Act will be very useful in order to provide answers and in order to face AI challenges, even though the AI Act has been highly criticized because of its difficult legal framework. There are almost 200 articles. The official act that has been published is about 400 pages, so it is very long. It is very difficult to understand, but there are many answers given by European Union institutions concerning the risks that have been very well highlighted by my colleagues, in particular concerning discriminatory bias that can be realized through AI algorithms, and how, for example, discriminatory bias have been faced by the EU AI Act by a risk management approach. So every company providing this kind of technology, before putting into the market the systems, must provide a lot of documents and a lot of proofs concerning the kind of data through which the softwares have been learned. So they must explain which kind of data have been given to the machine in order to be able to provide the output. And this kind of risk management is a very useful tool in order to avoid discriminatory outputs. The same approach has been realized by the Council of Europe Framework Convention. And the Framework Convention too establishes for the need for a risk management system. Risk management system providing a lot of duties for companies who would like to provide their services and their softwares into the market. And the Framework Convention has a universal scope because a lot of states are providing, have signed this convention. And even though we are talking about an international convention that usually are addressed to public authorities, in particular to state authorities, by Article 2 of the Framework Convention, it is addressed to private actors too. Always, firstly, there is a duty for states to ensure that private bodies will comply with these duties, but it is noteworthy that it is addressed to companies and so to private actors too. So my answer is yes. European legal rules that have binding nature, both the EU AI Act and the Framework Convention adopted by the Council of Europe, they have provided many duties in order to face challenges realized by discriminatory inputs that can be used and that can be useful in order to infringe minorities, for example, as my colleague was saying before. So there are tools that are very interesting in order to face these kind of problems.
Thank you, Professor.
Can I ask a question?
Yes.
Hello, everyone. My name is Ikra, and I'm a research associate with the Chair International Law here at IPRI. I believe that there is another debate emerging within this realm, and that is pertaining to accountability. So the question that I have is that who is going to be held accountable if an AI tool violates principles of international law? And interestingly, we already have AI tools that are doing so. For instance, Israel has been using such tools. We have tools like Lavender, Gospel, Alchemist, Red Wolf that are violating international law. And the issue in such situations is that we have an entire chain of players that are involved. So who is going to be held accountable? Is it going to be the developer? Is it going to be the programmer, the user, or the entity deploying AI? So if anyone could please comment on that. Thank you.
If I can give the perspective of the European Union institutions concerning this liability issue, this kind of topic has been regulated by a directive proposal by the European Union, starting from the EU AI Act. The EU AI Act provides for two main subjects involved in this chain value of the AI tools that you were referring to. In particular, we have the provider, that is the company developing the system, so the company that is behind the system, and then we have the so-called deployer, so the subject using the system. So the liability is shared by these two subjects. So the liability cannot be addressed directly to the AI because someone talked about an autonomous legal status of AI tools because of their autonomous character, because of their features. But actually, the answer given by European Union institutions is to have addressed and differentiated liabilities between the deployer and the deployer, that is the front-end operator, and the provider, that is the back-end operator. And on this point, there is a directive proposal. So the EU AI Act just introduces these notions, but does not deal with liability issue. What is dealing with liability issue is a directive proposal adopted by EU institutions. So now, so far, we do not have a binding legal rule yet, but it will be adopted soon, even though European Union institutions have announced it to not adopt it last week, unfortunately. But we have, so far, we have a directive proposal differentiating liabilities between the provider and deployer based on the notion of control. So analyzing the origin, the source of the damage. So if the damage is realized by the way through which the AI tool has been used, the liability will be for the deployer, the so-called front-end operator. But if the damage can be linked to the malfunctioning of the system itself, the liability will be for the provider, that is the subject that is behind the system. So this kind of sharing of liability between the provider and the deployer is the way followed by European Union institutions.
Thank you, Professor. Dr. Sadia or Mr. Nabil, would you like to chip in on that, or can we, because we have... Yep.
Other than the developer and deployer, there are other two aspects that should be considered. They're not enough. Obviously, they're not binding laws. But one is the end user, because a lot of these technologies also have a problem when they are misused by the end user, and there has to be some accountability for that. And the one more thing is the people who scrape data for these developers, because a lot of time they scrape data from sources which without informing the person whose data they are stealing. So they're also responsible in terms of when something goes wrong in terms of privacy leaks or other issues. So end user and in some cases, and the people who collect data anonymously from different sites.
Thank you. We have a hand raised by Barrister Talha Ali Khwaja, who wants to ask a question. Mr. Khwaja, we are going to unmute you, and so you can ask the question yourself.
Yes, thank you everyone for this opportunity, and thank you to all the speakers for their insightful presentations. Just start a small question. We know that these AI producing nations they have a clear advantage because of being the first in this race, much like the West used to have during the Industrial Revolution. What do you think about, let's say, a legal obligation on AI producing nations and maybe corporations too, so that we can ensure that the benefits of artificial intelligence are equitably distributed across developing countries? I mean, could we frame this as part of the right to development of every state in international law?
Yeah, I can take that if you don't mind.
Yes, sure.
Yeah, so that's a really good question. Thank you, Talha. In terms of creating an international obligation, I think right now international law is at a nascent stage when it comes to approaching AI. I think regional systems like the EU are perhaps a bit more ahead in this, but I do agree with you that there should be some sort of like a capacity building, a transfer of AI technology obligation upon global North states, particularly those states that have strong AI developing economies, to, again, not only transfer money, but the actual AI expertise, capacity building, training exercises. Whether this can manifest itself into a binding treaty, we have to wait and see, because I think right now there still are a lot of differences between, like we mentioned, approaches to AI regulation. And so until and unless globally we can come to a consensus about that, maybe at the UN level, for example, until we don't get to the overall, like the fundamentals of what AI regulation should look like, I think capacity building obligations would come in much later. But I do agree with you. I think that's very important, particularly from the global south. Yeah.
Thank you, Ras. We are going to take the last question now, and then we're going to go on to some brief closing comments from Professor Alberto and Dr. Raza. Khadija wants to ask a question, please.
Hi, everyone. My name is Khadija Khanam, and I'm a research associate with the Chair International Law here at IPRI. My question is for Professor Roberto. Professor, I would start by thanking you for such an insightful presentation. And my question for you is that, considering that the European Union AI Act is the first comprehensive AI regulatory framework for the artificial intelligence, how do you see it influencing the global governance of AI? And in your opinion, do you think that other regions like South Asia should adopt a similar model, or should they come up with their own models of the AI regulatory framework? Thank you.
I think Doctors Sadia and Ras can also chip into that with the Global South perspective later on. Yeah.
Thank you very much for your question. And I think that European Union institutions will be able to influence some other legal framework, because it had been the case, firstly, with the European Union GDPR. The European Union GDPR of 2016 has been the first regulation concerning with data protection. And it represented a model, a paradigm, a normative paradigm for also other players in the world. Many regulatory acts have been adopted on the ground of the EU GDPR, and maybe it will be the same with the AI Act. Maybe some other countries can make some greater efforts in order to improving this regulatory act that has got a lot of negative features, because sometimes it is too deep in some technical descriptions. Maybe restrictions for companies are too strict. So maybe a softer approach can be followed by other players. But it can be a model, a law model, a regulatory model for other players. And in particular, I hope that at international level, this a very great role could be played by the Framework Convention of the Council of Europe, because following the previous question, it is an international convention that so it is able to bind also not European states, obviously only when they will sign this convention, but it could be a really great model law, a really great model regulatory act in order to influence also United Nations a future legal framework, because we will have a legal framework adopted by the United Nations. This is the hope that has been provided by the expert group named by the Secretary General of UN. So we hope, or I hope, that the Council of Europe Framework Convention will serve as a model for the future United Nations legal framework. Thank you.
Thank you. Ras, would you have a perspective on the Global South? Do you think the AI Act will also impact the development of an AI regulatory act in South Asia?
Yeah, thank you for the question. I think it definitely will, and I think it is a good model legislation. However, I do think that, I would agree that maybe the approach that it adopts, like the risk management approach, like identifying what risks are like high risk, medium risk, low risk, I think that approach is good. It's just that we need to adapt that model for our own sort of social, political, cultural environment. I know, like Dr. Sadia mentioned, there's a lot of heightened tension around things like religious freedom. We have different notions of certain human rights here in South Asia, and different countries have different notions of human rights, which will be different from the European notion of human rights. So I think that when we approach the drafting of said law, we need to take into account what particular sensitivities would apply here, and adapt the definition of risks accordingly. But I think the approach of like the life cycle approach and the different liability, the staggered liability model that is taken, I think that will definitely provide a good foundation structure for the law. Yeah, thank you.
Thank you. Dr. Sadia, would you want to chip in on the community perspective of the Global South on this?
Well, not Global South, but of my own country. Khadija, what will happen is that Europe and America will fight, and whoever will be successful have set the standard for international law on AI. Thank God that they are on different pages, maybe on different books right now. But with regard to Pakistan, I give you a good example of GDPR. When Pakistan was drafting, Pakistan has actually a draft of data protection law, which was we have copied some articles as it is from GDPR without the explanation, without the recitals of that were mentioned in GDPR, and that made little sense. And then we add in our own thing, and that's my problem. There's no problem in getting inspiration from GDPR or any other law for that matter, or AI regulation from EU. But the problem is when you copy paste a certain aspect, then add in your own without giving it a perspective. That's a challenge. And also, not understanding your own domestic requirements. And I to be honest, I have no answer. When I was working on data protection, I was not sure which approach to take. Do we need more regulation and more control by state to ensure the national security, or to be more open to businesses and make sure that we have this growth of AI and IT companies and other developers. So that's a challenge that Pakistan has to see where they want to see their own domestic industry to be in next 10-20 years. But the ideal way is to think about your own domestic issues and then see what inspiration you can get from international law.
Thank you. I would now like to request Ambassador Dr. Raza Mohammed, President of the Samad Policy Research Institute, for his closing remarks.
Thank you so much. Thank you, everyone, the participants, the speakers, the organizers. Very great of you. It's a great contribution towards international law. Actually, when we talk of goods and bads of the AI, and especially when its use comes to our mind in the domain of international law, the thing which I can conclude is the experts like you are the ones who are going to actually steer formulations of laws, creations of the laws, which will be helping in harnessing the best potential of the AI, as well as stopping the illegal, or what you say is the ills of the AI. When it infringes the human rights, when it infringes the state, when it infringes the writ of the state also. Because the biggest risk when I ask the AI, what is the biggest risk you have? It says the deep fake. Because deep fake is one thing which is, I think, the greatest risk. And the best application of the AI, it says, is the medical domain. But when you come to the international law, there are so many AI tools which are being used now. For example, we have multiple tools. There was a tool called ROS, which was actually banned later on because of a litigation in the court. Then there's a LexisNexis is one. Then there is Kira, which is there for reviewing the contracts, and Hein Online, which has UN treaties and so on and so forth. So there are so many programs which can help the lawyers to undertake their research. But there are biases also. I read about a program, AI tool, which is called Compass. It says correctional offender management profiling for alternative sanctions. So this was the tool which was being used by a few of the courts. It is still being used. It actually tells you, will the offender commit another offense again? Will he repeat or she repeat the offense? So it is biased in a way that most of it is based on the historical facts, and it was very biased when it came to the color. People of color were the one which were given maximum sentence because their history, according to the historical archives of that program, people of color had committed more crimes. So it became a little biased. But when it comes to the AI's use and human rights in the war, the latest example is use of AI tools by Israel in a war against Hamas. So there were 3-4 tools. There was Gospel, there was Lavender, there was Where is Daddy? These were used. And acceptable, unfortunately, acceptable error was 15 to 20%. That if 15 to 20% are the incorrect killings, that was acceptable, number one. Number two, the collateral damage also came in. Dr. Sadia, I think, gave a very good point about the biases, the ethical and ideological biases. These are there. Then there is another problem that people from Japan, perhaps especially, and China, and all those who are not having mastery over English language, they kind of find it very, very difficult to use the AI tools, and especially when they have to formulate the AI prompts for the chat GPT and all that. So these are few of the ills, but I will conclude with 2-3 examples that, like a kitchen knife, you can use that knife for making good food, and also it could be used to kill someone. Same is the case with the roses. Whether you want to use a red rose or a black rose and so on and so forth. So it is like a fragrance if you want to put it for fragrance or put it in someone else's eyes. So AI could be used in a negative way and also positive way, but you are the people who are going to steer it. Thank you so much. And I thank Maham. I think Dr. Attila is not here. I thank him also and his organization and all of you who are here and my team for organizing this very, very useful event and a webinar. Thank you so much.
Thank you, Ambassador Reza. I now like to request Professor Alberto Malatesta, the Secretary General of ILAC, for his brief closing comments, please.
Me? Yeah? Can you hear? Yes, just a few words to thank you again, all of you, all the speakers, all the participants for these insightful comments on AI and its impact on international law. And I appreciate it very much, especially the different views, if I may say, the South of world view that it's quite different from ours. So I learned a lot, and I'm sure that there will be some other follow-ups in this matter. So again, thank you all, and hope to see you again very soon for other events like this one.
Thank you, Professor. In the end, on behalf of all 3 organizations, I would like to thank the speakers and the participants for taking out your time and for participating in our webinars across all the different time zones that we are in. We look forward to your participation in our future events, and goodbye for now. Thank you.
Goodbye. Thank you.
Thank you. Goodbye.
Thank you all.